Imagine a single courtroom verdict that decided who gets government jobs in India for entire generations. In 1992, 9 judges of the Supreme Court sat together to answer one explosive question: how far can reservation go? The answer, Indira Sawhney versus Union of India, still shapes every reservation debate in this country. In the next 7 minutes, let's break down the case, what led to it, what the 9 judges ruled, and why it still matters. Our story begins in 1979. The Janata Party government of Morarji Desai set up the Second Backward Classes Commission, chaired by B.P. Mandal, the famous Mandal Commission. Its job, identify India's socially and educationally backward classes and suggest measures for their advancement. In 1980, it submitted its report. The other backward classes, the OBCs, made up roughly 52% of India's population. Its headline recommendation, 27% reservation for OBCs in central government jobs and public sector companies. Add the existing 22.5% quota for scheduled castes and tribes, and the total hit roughly 49.5%. But the report gathered dust for a decade, until 1990. In August 1990, Prime Minister V.P. Singh announced that his government would implement the Mandal report. The country erupted. Supporters called it long overdue social justice. Opponents, mostly upper caste students, called it the death of merit. Protests swept northern India, trains stopped, campuses shut, and tragically, students like Rajiv Goswami immolated themselves in protest. Then, in 1991, the new government of PV. Narasimha Rao kept the 27% OBC quota but added 2 changes, an economic criterion and 10% reservation for the poor among the higher castes. The total now crossed 59%. Writ petitions flooded the Supreme Court, and one lead petitioner was an advocate named Indira Sawhney. The petitioners argued, caste cannot be the test of backwardness. Quotas kill merit. Crossing 50% destroys equal opportunity under Article 16, and poverty, not caste, should decide who gets help. The government defended the orders as constitutional social engineering under Article 16, Clause 4, which empowers the state to make special provision for backward classes who are not adequately represented in public services. The stakes were so high that the case went to a 9-judge constitution bench, the largest since the legendary Kesavananda Bharati case. On the 16th of November 1992, the verdict arrived. 6 judges to 3, spread over 700 pages. Holding number 1, caste can be a test of backwardness. A backward class under Article 16 need not look identical to the scheduled castes and tribes. Caste can be one criterion of social and educational backwardness, but never the sole criterion. Poverty alone, without social backwardness, does not qualify. In short, caste matters, but caste alone is not enough. Holding number 2, the 50% ceiling. Reservations, the court ruled, must not exceed 50% of appointments in a year. Equality is the rule. Reservation must remain a limited exception, except in truly extraordinary situations. Because of this ceiling, the extra 10% quota for the poor among the forward castes was struck down. A purely economic criterion does not fit Article 16.4. Ironically, Parliament revived that idea in 2019 through the 103rd Amendment, creating the EWS quota by changing the Constitution itself. Holding number 3, the creamy layer, the judgment's biggest innovation. Within every backward class, those who have already risen, the socially advanced and well-off, must be excluded from quota benefits. Reservation, the court insisted, is for the genuinely disadvantaged. It must not become a hereditary privilege for the affluent few within a caste. This principle took effect in 1993, with an income bar revised upward ever since. Holding 4. No reservation in promotions. Article 16.4 covers initial appointments only. Parliament later reversed this for SCs and STs through the 77th Amendment in 1995. Holding 5. Quotas do not destroy merit. Merit is not just exam marks. Fair representation is itself part of efficient, inclusive governance. Article 16.4 is not an exception to equality. It is an emphatic way of achieving it. And holding 6. A permanent statutory body must decide who enters or exits the OBC list. The National Commission for Backward Classes, created in 1993 and given constitutional status in 2018. So what changed on the ground? The 27% OBC quota survived. It stands to this day. The 50% cap became the golden rule of reservation law, invoked in nearly every quota battle since, from the Maratha case to state laws trying to breach the limit. The creamy layer filter still decides who among OBCs actually benefits, and the judgment's core idea. Reservation is about representation, not poverty relief. Anchors the debate to this day. Critics say the case froze an arbitrary 50% line. Supporters call it a masterful balance, social justice with guardrails.
3 decades later, Indira Sawhney is not just a name law students memorize. It is the rulebook, a 50% ceiling, creamy layer exclusion, caste as one factor among many, and courts reviewing who is truly backward. Every time a community demands quota, Patidars, Marathas, Jats, the courts reach back to this 1992 verdict. If this breakdown helped you, hit like, subscribe for more landmark case explainers, and tell me in the comments, should the 50% limit stay, or is it time for a rethink? See you in the next one.